Hello friends, welcome to my course on microbial biotechnology. Today we are starting module number 12, which is patenting in microbial biotechnology. In this first lecture, we will be having an introduction to intellectual property and patent law, then biotechnology patents, the application process of patents, legal and ethical considerations of patents. So, these whole lecture is divided into several sections. For example, section 1 deals with the introduction to intellectual property, where we define what is intellectual property and what are the types of intellectual property, particularly patents, trademarks, copyrights, trade secrets, the role of IP in innovation and biotechnology. Then we also have an overview of the global intellectual property system. The section 2 deals with fundamentals of patent law. Section 3 deals with the overview of biotechnology patents. Section 4 deals with the patent application process. Section 5 deals with international perspectives on patent law, and section 6 deals with the legal and ethical considerations. The other sections will describe the details before we begin them as and when the time comes. So, here in section 1 we have this introduction to intellectual property, where we try to define what is IP and what are the types of IP. Particularly, the origin of IPR can be traced to the idea of trade secrets, privilege rights or monopoly in ancient time, followed by various civilizations to promote science and arts. So, if we want to define, we can tell intellectual property refers to creations of the mind, human mind, that have commercial value and are protected by law. It provides legal rights to the creators or owners over their inventions, literary and artistic works, symbols, names, images and designs used in commerce. Spinello in 2006 describes intellectual property rights as necessary to maximize social utility by providing authors, inventors and other creators with durable and tangible return on their investment of time, labor and other resources used in the creative process. So, broadly the types of IPR we will cover here includes the patents, copyrights, trade secrets and trademarks, but then there are many other type of IPRs like design, etc. So, let us discuss about patents. They grant exclusive rights to inventors for a specific period, usually 20 years, to prevent others from making, using or selling an invention. These are applicable to new inventions, processes or compositions. Then comes the trademarks, which protect brand names, logos, symbols or slogans that distinguish goods and services. It helps in building brand identity and consumer trust. Then we have copyrights, which protects original work of authorship, including literary, artistic and certain other intellectual works, and protection lasts for the life of the author plus 70 years in many jurisdictions. Then we have trade secrets, which protects confidential business information that gives a company a competitive edge, such as formulas, practices, designs or processes. Unlike patents, trade secrets are not disclosed to the public. What is the role of intellectual property rights in innovation and biotechnology? Patent is the most prized possession of an inventor, as told by Sangal, and he highlights that having a patent makes one feel proud, which encourages innovation and investment. So, IP has a big role to play in innovation. IP rights encourage innovation by granting creators exclusive rights to benefits commercially from their inventions and creations. This exclusivity provides an incentive to invest time, effort and resources into developing new technologies and products. The role of IP in biotech industry is crucial for protecting groundbreaking research, processes and products. Patents, for example, are vital for safeguarding innovations such as genetically modified organisms, new microbial strains and biotechnological processes. By securing intellectual property rights, companies can attract investment, foster partnerships and bring innovative solutions to market, driving advancements in medicine, agriculture and environmental management. Let us now have a overview of the global intellectual property system. The global IP system consists of international treaties and national laws that govern the protection and enforcement of IP rights across borders. IP laws are different from one country to another, and they also have many similarities. So, as you can see in this cartoon, this symbol is interpreted as two different digits based on the angle of observation. So, what are the key international treaties? The first one is the TRIPS agreement. It stands for trade related aspects of intellectual property rights. It sets a minimum standard for IP protection globally enforced by the World Trade Organization. Because there is so many differences, as you can see in this cartoon symbolically. So, TRIPS helps us in setting a minimum standard across the globe. Then we have the Patent Cooperation Treaty, which facilitates the process of obtaining patents in multiple countries through a single international patent application. But at this point, we need to remember that there is nothing called global patent or international patent. Patents are limited by the jurisdiction of the country it is filed in. But a Indian innovator can patent abroad, and that patent will be having jurisdiction in that particular country where it is filed. Then we have the Madrid system, which simplifies the process of registering trademarks internationally through a single application, and aspects like harmonization and enforcement are also being there in place through a global framework which supports international trade, investment and innovation by providing a reliable system for protecting IP across different jurisdictions. Let us now go into section 2, where we will discuss the fundamentals of patent law. We will try to examine what is a patent, what is the legal definition of a patent, and what is the purpose of a patent, what are requirements for patentability, particularly novelty, non-obviousness and utility, and what are the different types of patent, utility, design and plant patents. Then patent life cycle, how to file, how you examine, how patents are granted, and how maintenance of patents are very important. So, patent is a legal right to protect a new innovation, invention, idea, discovery or concept having a commercial value. It is a time limited legal right assigned to an inventor by the government of a country where the patent is filed to protect the invention from being misused. In biotechnology, the Cohen, Boyer and PCR patent is a well known example having a very high commercial value, and even in the time of COVID, a derivative of the PCR, the real time PCR was a very highly commercial success. The basic criteria for the patentability of an innovation are that it should be novel, non-obvious and useful, as described by Burton in 2000. The patenting of genetically modified organisms, microorganisms, came into existence in 1980 after the US Supreme Court's ruling in Chakraborty for Pseudomonas bacteria capable of cleaning oil judgment was given. And from the legal point of view, a patent is a legal right granted by a government authority to an inventor, giving them the exclusive right to make, use, sell and import their invention for a limited period, typically 20 years from the filing date. The purpose of a patent is to encourage innovation by providing inventors with a temporary monopoly on their inventions in exchange for public disclosure of the invention's details. Now, let us look into what is patentable and what is not patentable. So, briefly we call the requirements of patentability, novelty, obviousness and utility. So, novelty basically tells that the invention must be new and not known or used by others before the patent application is filed. It must not have been previously disclosed in any form, including publications, public use or sales. Now, here is a twist. The patent may be novel, the invention may be novel, it has been done by the inventor, but the inventor has published it prior to patenting. So, in certain jurisdiction, this will actually act against this criteria of novelty. So, that is why in certain cases the inventor needs to patent first and then go for publication. So, next comes the inventiveness or non-obviousness criteria. The invention must be sufficiently inventive or non-obviousness. There may be certain cases where there is a inventiveness, but it is actually incremental, but that may not be considered good enough to be considered to be patentable. So, this non-obviousness means it cannot be an obvious improvement or combination of existing knowledge to someone skilled in the relevant field. So, by just manipulating existing knowledge, combining them and claiming to be new invention may actually not be helpful because these are not obvious, non-obvious, these are obvious. So, everything which is novel and which is non-obvious may not be patentable again until and unless it has some kind of a utility. The invention must be useful, meaning it must have practical application or provide some identifiable benefit. It cannot be purely theoretical or speculative. So, we have many mathematical theories which are very famous, but those are not having direct utility in the shape of a product or a service. So, from the patent point of view, there are no doubt great ideas in science or in other subjects, but they may not be patentable from the utility point of view. So, now let us discuss into the type of patents. We discussed about the type of IPRs earlier. So, now among them patent is one of the IPR. So, now when we want to classify patents, these may be utility patent, design patent and plant patents. The utility patents cover new and useful processes, machines, manufacturers or compositions of matter or any new and useful improvements thereof. This protect the functional aspect of an invention. Then we have design patents which protect the ornamental design or appearance of a manufactured object. Design patents are granted for 15 years from the date of grant in the United States, and it varies from country to country. Then we have the plant patents granted to anyone who invents or discovers and asexually produces a distinct and new variety of plant. This includes cultivated, spores, mutants, hybrids and newly found seedlings other than tuber propagated plants or plants found in an uncultivated state. So, let us now look into the patent life cycle starting from filing, examination, grant and maintenance. The first important thing is filing. The patent process begins with the submission of a patent application to a government agency of a particular country. This includes detailed descriptions, claims and drawings of the invention. Once it is filed to the patent agency, it undergoes examination. After filing, the patent office examines the application in multiple rounds to ensure it meets all legal requirements for patentability, particularly including novelty, non-obviousness and utility. Then when these are found to be meeting all these requirements, or it passes the examination phase, the patent is granted, giving the inventor exclusive rights to the invention. The grant is then published and the patent becomes enforceable. After the patent is granted, the owner must pay maintenance fees to keep it in force. These fees are typically required at regular intervals during the patent's life cycle. Fees are also required at the filing stage itself. Let us now move on to section 3, where we will be having an overview of the biotechnology patents. We will discuss about the historical development of the biotechnology patents, the key legal precedents and some of the landmark cases, scope of biotech patents, processes, products and organisms, and the ethical and social considerations in biotech patenting. From the historical point of view, the first significant patent related to biotech was issued in 1873 to Louis Pasteur for his discovery of a purified form of yeast, making the beginning of microorganism related patents. However, biotechnology patents gained momentum in the 1980s with the advent of recombinant DNA technology and molecular biology in the true sense. A pivotal movement came in 1980 with the Diamond versus Chakraborty case, where the US Supreme Court ruled that genetically modified organisms could be patented. Ananda Chakraborty, a scientist at General Electric, developed a bacterium capable of breaking down crude oil, which was subsequently patented. These landmark decisions establish that anything under the sun made by man could be patented, significantly broadening the scope of patentable subject matter in biotechnology. The Human Genome Project in 1990s further fueled the growth of patents on human genes, with thousands of gene sequences patented before the practice became more restricted due to ethical concerns and legal reforms. So, this is the historical development in the molecular biology and recombinant DNA technology, starting from and also the classical microbiology starting from 1973, the contribution of Pescher regarding the purified form of an yeast, which was patented. Then in 1973, one of the landmark discoveries of the double stranded DNA helix structure, although it was not patented. Then comes the 1980 landmark case of Diamond versus Chakraborty. And then in 1980, the first genetically modified plant is created. Then 1970, the start of the human genome, and 1997, Dolly the sheep, the first cloned mammal, is born, and 2001 TRIPS agreement includes provisions for biotech patents. So, this is a comparison of the various developments over time that leads to the biotech patenting revolution. Then we have 2012, the CRISPR-Cas9 gene editing technology, which is developed, and then 2013 Association for Molecular Pathology versus Myriad Genetic US Supreme Court decision case. So, these are the legal precedents and landmark cases. This Diamond versus Chakraborty case already mentioned. The US Supreme Court case was a turning point as it affirmed the patentability of genetically modified organisms, setting a precedent for the patenting of life forms. Then comes the Association of Molecular Pathology virus Myriad Genetics 2013 case, where the US Supreme Court ruled that naturally occurring DNA sequences cannot be patented even if isolated. However, cDNA, which is synthetically created, was deemed patentable. This case significantly impacted the biotech industry by restricting the patenting of human genes, which has been a common practice for some time. Then there is a Mayo Collaborative Services versus Prometheus Laboratory in 2012 case, which dealt with the patentability of medical diagnostic methods. The Supreme Court ruled that simply applying a natural law or abstract idea using routine and conventional methods does not qualify for patent protection. The decision raised the bar for patenting biotechnological processes involving natural laws. Then comes the CRISPR patent disputes. The CRISPR-Cas9 gene editing technology has been at the center of a complex and ongoing patent battle between major institutions like the University of California, Berkeley, and the Broad Institute. The dispute highlights the challenges in patenting cutting-edge biotechnological innovations with broad applications. So, what are the scope of biotech patents? Processes, products, and organisms. Biotechnology patents, from the process point of view, often cover novel processes used in the creation, modification, or analysis of biological materials. This includes methods for gene editing, recombinant DNA technology, fermentation, cell culture, and diagnostic techniques. Process patents are vital in industries like pharmaceuticals, agriculture, and industrial biotechnology. Then we have products. Patents can protect biotechnological products such as genetically engineered proteins, enzymes, therapeutic antibodies, and vaccines, and also includes genetically modified organisms, GMOs, including crops with enhanced traits like pest resistance or improved nutritional content. The patenting of products allows companies to secure exclusive rights to valuable innovations, ensuring a return on investment. And the patenting of living organisms such as genetically modified bacteria, plant, and animals has been a controversy of biotechnology patents for long. Genetically engineered organisms which exhibit new traits or capabilities like pest resistant crops or oil eating bacteria are frequently patented. The patentability of organisms raises ethical questions, particularly when it involves higher life forms. So, the ethical and social consideration in biotech patenting is an important subject to study. The patenting of life forms raises questions about the ownership of living organisms and the moral implications of commodifying life. Critics argue that patenting genetically modified organisms and human genes can lead to exploitation, restrict access to essential medicines, and hinder scientific research. The access to genetic resources is another ethical issue concerning indigenous communities and biodiversity rich regions. The Nagoya Protocol under the Convention on Biological Diversity seeks to address these concerns by ensuring fair and equitable sharing of benefits arising from the use of genetic resources. The integration of these principles into patent law remains a challenge. Biopiracy is a related concern where companies or institutions patent traditional knowledge of biological resources without proper acknowledgement or compensation to the communities that have historically nurtured them and or innovated them and used them for long. This practice has led to calls for more stringent regulations to prevent the exploitation of indigenous knowledge and resources. The so-called Inola yellow bean variety that has been at the center of a decade-long biopiracy case, you can see here in this picture. The impact on innovation is also a significant consideration. While patents incentivize innovation by providing exclusive rights, they can also create patent thickets where overlapping patents on fundamental biotechnologies hinder further research and development. This is particularly evident in areas like gene editing technologies and personalized medicine, where broad patents can stifle competition and delay the introduction of new treatments. The public perception of biotechnology plays a crucial role in shaping the ethical landscape. The patenting of genetically modified crops and organisms often faces public opposition, particularly in Europe and developing countries, due to concerns about environmental risks, food safety and corporate control over agriculture. Let us now go to section number 4, where we will try to learn about the patent application process. What are the steps in filing a patent, from invention disclosure to granting of a patent, preparation a patent application, drafting claims, prescriptions and drawings, conducting a patent search and evaluating prior art, patent prosecution of its actions, amendments and appeals. Let us start with the steps in filing a patent. So, the inventor documents the invention in detail. This step we call as invention disclosure, including how it works, its purpose and its potential applications, typically submitted to the legal or intellectual property department of an organization or directly to a patent attorney if the inventor is filing independently. Basis for evaluating patentability and preparing the patent application. Then we have the pre-filing considerations. So, before filing, it is crucial to conduct a thorough patent search to identify existing patents and publications related to the invention. This helps assess the novelty and non-obviousness of the invention. Inventors must decide whether to file a provisional or non-provisional patent application. A provisional application establishes an early filing date, but does not mature into a patent unless a corresponding non-provisional application is filed within 12 months. Then comes the patent application preparation. Once the decision to file a patent is made, the patent application is prepared. This involves drafting detailed claims that defines the scope of the invention's protection, along with descriptions and drawings that fully explain the invention. The application must meet all formal requirements to ensure it is accepted by the patent office. So, we file the patent application. The prepared patent application is filed with the relevant patent office, example the United States Patent and Trademark Office, European Patent Office or Indian Patent Office, depending on the jurisdiction we are interested in, which means the country we are interested in. Upon filing, the application is assigned a filing date which establishes the priority date for the invention. Then comes the examination phase. After filing, the application undergoes examination by a patent examiner. The examiner reviews the application to determine if it meets all legal requirements, including novelty, non-obviousness and utility. The examiner may issue office actions requesting clarifications, amendments or rejecting the claims. Then comes the patent prosecution phase. The applicant must respond to any of his actions issued by the patent examiner. This phase, known as patent prosecution, may involve amending the claims, providing arguments or evidence and negotiating with the examiner. If the application is rejected, the applicant may appeal the decision or request reconsideration. Then comes the grant of a patent. If the application successfully meets all requirements, the patent is granted. The patent grant is published and the inventor receives the exclusive rights to the invention. Maintenance fees must be paid to keep the patent in force throughout its term, which is typically 20 years from the filing date. Preparing a patent application is very important. So, where we have drafting the claims, descriptions and drawings. Drafting claims are very important. These are the most critical part of the patent application as they define the legal scope of the patent's protection. Claims must be precise, clear and broad enough to cover variations of the invention, yet specific enough to avoid encompassing prior art. There are two main types of claims: independent claims which stand alone and dependent claims which refer to and further limit an independent claim. Then comes the descriptions or specifications which provide a comprehensive explanation of the invention, including how it works, its components, how it can be used or made. The description must be sufficient to enable a person skilled in the relevant field to replicate the invention without undue experimentation, and also support the claims by providing the necessary context and details. Then comes the drawings, which are required when they are necessary to understand the invention. They illustrate the invention's components, structure and operation. Well prepared drawings can clarify the claims and descriptions, making the application more robust. Drawings should be clear, accurate and aligned with the claims and descriptions. Conducting a patent search and evaluating prior art is the most another important operation. The goal of a patent search is to identify existing patents, published patents, applications and non-patent literature, example scientific papers, technical reports that are relevant to the invention. A comprehensive search helps determine whether the invention is novel and non-obvious, helps to identify potential competitors and avoid infringing on existing patents. Then comes the evaluation of the prior art, which refers to any evidence that an invention is already known before the filing date of the patent application, such as previous patents, publications of products. The applicant must ensure that the invention is sufficiently distinct from prior art to meet the criteria for patentability. Then comes freedom to operate analysis or FTO, which is often conducted to ensure that commercializing the invention will not infringe on existing patents. This analysis is particularly important in crowded technological fields where multiple patents may cover overlapping aspects of a technology. Then comes an important topic, the patent prosecution, office actions, amendments and appeals. Office action is a formal communication from the patent examiner detailing objections, rejections or requests for additional information regarding the application. Common reasons for rejection includes lack of novelty, obviousness or insufficient disclosure. The applicant must respond to office actions within a specified time frame, addressing each issue raised by the examiner. In response to an office action, the applicant may amend the claims, descriptions or drawings to overcome the examiner's objections. So, this is the amendments which must be carefully crafted to avoid introducing new matter that was not originally disclosed in the application. The goal is to align the application with the examiner's requirements and maintaining the desired scope of protection. Then if the application is rejected, the applicant may appeal the decision to a higher authority within the patent office or to a judicial body such as the Patent Trial and Appeal Board (PTAB) in the United States, or in other countries it will have similar such judicial bodies. This involves presenting legal arguments and evidence to support the patentability of the invention. Let us now go to section 5, where we will be discussing about the international perspectives on patent law. We will compare the patent systems in US, Europe and Asia. Then we look into the international treaties and agreements like TRIPS, PCT and Budapest Treaty. Then we look for discuss harmonization of patent laws and global IP strategies, managing IP in multinational biotech companies. In the United States, the US patent system is governed by the US PTO or United States Patent and Trademark Office. The system emphasizes a first to file principle, which is adopted of the America Invents Act of 2011. Then the US patents typically last 20 years from the filing date, subject to the payment of maintenance fees. The system is known for its broad patent eligibility, particularly in biotechnology and software. Some of the key features include the possibility of provisional applications, which allow inventors to secure an early filing date while refining their invention. In Europe, we have the European patent system managed by the European Patent Office or EPO under the European Patent Convention. It allows for a centralized application process granting patents that are enforceable in multiple European countries. The EPO has stringent examination standards for inventive step, non-obviousness and industrial applicability. Biotechnology patents face rigorous scrutiny, especially in areas involving ethical considerations such as gene editing and human embryonic stem cells. Patent term is 20 years from filing with the option for supplementary protection certificates to extend protection for pharmaceuticals and plant protection products. In the case of Asia, we have China, Japan and South Korea. The China National Intellectual Property Administration oversees patents. China's patent system has rapidly evolved with significant reform to strengthen IP protection and enforcement. Patents in China are increasingly aligned with international standards, through enforcement remains a challenge. Then the Japan Patent Office is known for its efficiency, offering a super accelerated examination process for high priority applications. Japanese patents focus heavily on industrial applicability and detailed descriptions. We have the Korean Intellectual Property Office in South Korea, which is recognized for its advanced IT systems and fast tracking programs. South Korea emphasizes innovation in technology and biotechnology with robust IP enforcement mechanisms. So, some of the international treaties and agreements are TRIPS, PCT and the Budapest Treaty. These treaties facilitate the harmonization and enforcement of patent laws across borders. TRIPS is administered by the World Trade Organization or WTO. TRIPS establishes minimum standards for IP protection, including patents across all World Trade Organization member countries. The mandate of TRIPS is that patent must be available for any invention in all fields of technology, provided they are new, involve an inventive step and are capable of industrial application. It also requires patent protection for at least 20 years from the filing date. Here we can see Jayashree Wattal, counselor in the Intellectual Property Division of the WTO. Then the Patent Cooperation Treaty is administered by the World Intellectual Property Organization WIPO, which simplifies the process of filing patents in multiple countries. A single PCT application allows inventors to seek patent protection in over 150 member states. The PCT system provides a centralized initial phase or the international phase that includes a preliminary search and examination, which is followed by national or regional phases where the application is examined according to local national laws. So, the countries shown here in green are the Patent Cooperation Treaty members. Almost all countries of the world, including India, you can see here are members of the PCT. The next important treaty internationally is the Budapest Treaty, which addresses the specific needs of biotechnology patents by allowing the deposit of microorganisms with an international depository authority as a means of fulfilling patent disclosure agreements. This treaty simplifies the patent process for inventions involving microorganisms, ensuring that deposits are recognized globally, reducing the need for multiple submissions. We will discuss about these in a little bit of detail in the next lecture. Another important issue is the harmonization of patent laws and global IP strategies. Harmonization of patent laws aims to standardize the legal framework across jurisdiction, reducing complexity for inventors and multinational companies. So, there are various efforts at harmonization. Efforts to harmonize patent laws include initiatives by the WIPO, the EPO and the USPTO to align examination procedures and standards, which include agreements on the definition of patentable subject matter, prior art considerations and patent term extensions. The substantive patent law treaty SPLT, though not yet adopted, represents an ongoing effort to unify substantive patent law principles globally. Then another important issue is the global IP strategy for multinational companies who have diversified business interest in as many countries. So, multinational companies must navigate varying patent laws while protecting their innovations across different markets. A global IP strategy often includes regional filings, filing patent in key regions, example US, Europe, China, and even in a populous country like India, based on market potential, manufacturing locations and legal considerations. Then patent portfolio management, prioritizing patents that align with business objectives and regularly reviewing and pruning portfolios to optimize value. Then the cross-border enforcement, leveraging international treaties and regional agreements to enforce patent globally while remaining vigilant against infringing activities in different jurisdictions. Managing IP in multinational biotech companies involves complex challenges and strategic considerations like portfolio management. Biotech companies typically manage large portfolios of patents covering products, processes and enabling technologies. Then strategic decisions are made regarding where and when to file patents, taking into account regulatory environments, market entry and potential collaborations. Then licensing and partnership are common in biotechnology, allowing companies to monetize their IP or gain access to complementary technologies. Cross-border licensing requires careful negotiation to account for different legal systems, royalty structures and the enforcement mechanisms. Another important issue is the regulatory compliance. Biotech companies, particularly MNCs, must align their patent strategies with regulatory requirements for drug approval, environmental safety and genetically modified organisms. This alignment ensures that patents provide meaningful protection throughout the product life cycle. Then litigation and enforcement are also important issues. Multinational biotech companies often face patent litigation in multiple jurisdictions. Effective IP management involves preparing for potential disputes, understanding the litigation landscape in different countries and developing strategies for defending and enforcing the patents. We now come to section 6 where we discuss the legal and ethical considerations with respect to IP, particularly the patentability of life forms and genetic material, the controversy over patenting genetically modified organisms, ethical issues in patenting human related microbiome research, access and benefit sharing, the Nagoya Protocol and biodiversity. Patentability of life forms, whether life is patentable. The legal background is the patentability of life forms including microorganisms and genetic material has been a contentious issue since the landmark 1980 US Supreme Court case judgment on the Diamond versus Chakraborty case, which we have mentioned in earlier part of this lecture. This established that genetically modified microorganisms could be patented. This ruling paved the way for broader patent claims over living organisms, genes and genetic sequences. From the global point of view, different jurisdictions have varying approaches to the patentability of a life form. Some agree and while some disagree. In the US, the scope is broad, allowing for patents on genetically modified organisms, isolated genes and certain naturally occurring substances. The European Patent Office allows patents on biotechnological inventions, but excludes plants and animal varieties as well as processes for modifying these. Some countries like India and Brazil have stricter regulations and limitations regarding the patentability of genetic material and life forms, reflecting cultural and ethical considerations. So, there have been many controversies over patenting genetically modified organisms. There is a public debate. The patenting of GMO has sparked significant controversy, raising concerns about food security, environmental impact and corporate control over the food supply. GMO patents enable large corporations to monopolize essential agricultural resources, limiting access for farmers and consumers, incentivize innovation in agricultural biotechnology, leading to the development of crops that are more resistant to pest diseases and environmental stresses. Some of the legal challenges include centering on the scope and enforcement of the GMO patents, including cases where companies have sued farmers for allegedly infringing patents by saving and replanting the patented seeds. These cases highlight the ethical and social dilemmas surrounding the ownership and control of genetically engineered organisms, particularly when they involve essential food crops. The ethical issues in patenting human related microbiome research is also an important issue, which an emerging field. The human microbiome comprise trillions of microorganisms living in and on the human body, representing a frontier in medical research with significant commercial potential. Patents related to the human microbiome raise ethical questions about the ownership of biological data and the commodification of human associated microorganisms and the implications of personalized medicine. So, some of the ethical considerations include the potential for exploitation in the collection and use of human microbiome data, particularly from vulnerable populations. There are also concerns about equity in access to microbiome based therapies and the long term impacts of altering the human microbiome for therapeutic purposes. The patenting of microbiome based inventions may restrict research and innovation by limiting the availability of fundamental research tools and data. Let us now have a small discussion on access and benefit sharing, particularly the Nagoya Protocol and biodiversity. The Nagoya Protocol on access to genetic resources and the fair and equitable sharing of benefits arising from the utilization, which is a part of the Convention on Biological Diversity (CBD), establishes a legal framework for the use of genetic resources. It aims to ensure that benefits derived from the use of genetic resources are shared fairly with the countries and communities that provide them. What are the implications of patenting? The Nagoya Protocol has significant implications for patenting in microbial biotechnology, particularly regarding the use of genetic resources from biodiversity rich regions. Companies seeking to patent innovations derived from these resources must comply with access and benefit sharing agreements, which may include monetary and non-monetary benefits to the source country or community. And the protocol raises important ethical considerations about biopiracy, the exploitation of indigenous knowledge, and the equitable sharing of profits from biotechnological advances. With this, we come to end of today's lecture. Thank you for your kind attention.